Good evening, everyone. On behalf of the Corporate Law and Financial Regulation Program of the Melbourne Centre for Commercial Law, I'm delighted to welcome you to tonight's seminar by Professor Ernest, who's visiting us from the National University of Singapore. I'd like to start by acknowledging the traditional owners of the lands on which we're meeting today. For those attending in person, we're meeting on the lands of the Wurundjeri, Woiwurrung and Bunurong peoples. And I pay respect to their elders, past and present, and to any First Nations people who are joining us here today. Now, the topic of tonight's seminar is Fiduciary Duty and Corporate Externalities, Rethinking Directors' Climate Obligations. When Professor Lim first suggested this topic to me, I responded enthusiastically because the themes that Professor Lim develops in his paper also resonate in Australia. Since we began corresponding about tonight's presentation, the topicality of these themes has only grown. So about Professor Lim, there's a little bit more information in the bio that was circulated advertising the seminar. I won't do it all, otherwise we won't have time for the seminar. But he holds the Chan Sek Keong Chair in Private Law at the Faculty of Law, National University of Singapore. He also serves as Vice Dean and Co-Director of the Centre for Technology, Robotics, AI and the Law. Melbourne Law School's been very fortunate because Professor Lim gave a seminar last night as well. So we're getting to hear on two of his primary interests, which are many, but include sustainability and artificial intelligence. And tonight we're going to be hearing more on the sustainability theme. But without more, I will hand over to Professor Lim.
Good evening, everyone. Thank you so much for coming. Huge thanks to Elizabeth, and big thanks to Rosemary for hosting me. So the title of my presentation today is Fiduciary Duty and Corporate Externalities, Rethinking Directors' Climate Obligations. So the long version of this paper is available on SSRM, and a shorter version of this paper can be found as a chapter in the Oxford Handbook of Climate Change and Private Law, which is edited by me and Douglas Kaiser from Yale Law School. So this handbook covers all aspects of private law. And in this handbook, we seek to examine the impacts of climate change on all areas of private law and vice versa. We have a universal aspiration when we decide to edit this handbook, and therefore it consists of 46 chapters from 62 contributors and 44 institutions and 14 common law and civil law jurisdictions. And I'm very pleased to say that there are actually 3 contributors from Australia, and I should mention 4 because Sam Bookman has just joined Melbourne Law School recently. So in Melbourne Law School, Jackie Peel and Sam Bookman contributed 2 chapters. Jackie Peel contributed a chapter on a jurisdiction-specific chapter covering climate litigation and climate action mechanisms in Australasia. And Sam Bookman contributed a chapter on Indigenous peoples and private law. Now, one of the instructions from OUP when we decided to edit this handbook is that we have to be original, we have to push the boundaries, and we shouldn't be restating or rehashing the existing literature. So it's with this in mind that I wrote this paper. At the outset, I should distinguish between the internal and the external dimension of directors' duties. The internal dimension of directors' duties is concerned with this question: whether directors are legally permitted or legally required to take into account climate-related risks and opportunities, insofar as doing so has a material impact on the company's interests, often equated with shareholder value or firm value. Now, in my view, this is an uncontroversial question, partly due, thankfully, to the foresight and the vision of you fellow Australians, because in the year 2016, Noel Hartley SC and Sebastian Hartford Davis was asked to write a legal opinion. They were commissioned by the Centre for Policy Development in Australia to specifically address this question: whether directors of limited liability companies can and should take into account climate-related risks if doing so has an impact on the company's interests. And The opinion, which has been cited all over the world and has been extremely influential, is that yes, failure to do so could render directors in breach of their duties of care, and as well as the fiduciary duties. And this legal opinion has been updated in 2019 and 2021. In 2023, Pollination and the Commonwealth Climate and Law Initiative, of which I serve as a trustee, is a London headquartered NGO, commissioned once again, the Aussie barristers, Sebastian Hartford Davis and Zoe Bush, to write a legal opinion to address this specific legal question, whether directors are legally permitted or legally required to take into account nature-related risks and opportunities in the decision-making process, insofar as doing so has a material impact on the company's interests. And the answer provided by them in this influential legal opinion that's been cited by The Economist and Financial Times is a resounding yes. And the failure of directors to do so could render them in breach of their fiduciary duties. This is the internal dimension of directors' duties, and this is not the subject of today's talk. The subject of today's talk is slightly more controversial. It's much more unsettled as a point of law in many jurisdictions. And the question is whether directors can and should take into account climate or nature-related risks and opportunities, even if doing so is not related to firm-specific interests, even if doing so is not related to shareholder value in the short term, even if doing so may result in the reduction of shareholder value, at least in the short term. This is the question I'm addressing in this talk. Now, you may be wondering, why am I addressing this specific legal question? Why am I addressing the external dimension of directors' duties? There are three major developments worldwide that underscore the importance of addressing this question. The first is the universal ownership debate, and I will also cover the important Delaware Court of Chancery decision, McRitchie versus Zuckerberg. The second relates to two pieces of legislation that have extraterritorial effect, the EU CSDDD and the EU CSRD, the Corporate Sustainability Due Diligence Directive and the Corporate Sustainability Reporting Directive. These two pieces of legislation, as I said, have extraterritorial effect, and therefore it affects Australian companies provided that they satisfy the threshold requirements stated in these two pieces of legislation. And this question is particularly important in the context of state-owned enterprises, and state-owned enterprises are key players in the decarbonization debate, and they are also major emitters. Now, after explaining these three motivations, I will explain three arguments that can support the external dimension of directors' duties. The first is that we can incorporate nature-related clauses into the corporate constitution, and here I will draw on the UK example. Second, we can cater to shareholders' preferences, and here I will draw from the US. And third, and this is the contribution I hope to make to the literature, is that in my view, there can be an alignment of the duties of directors, the duties of the state as a controlling shareholder, and the duties of the state as an asset owner in a state-owned enterprise. And here I will draw from the PRC, from the Chinese example. Now, as I mentioned, the external dimension of directors' duties is concerned with the adverse impacts that companies cause to society, to the environment, nature, climate, and the community. Many of us here will be familiar with double materiality, and it consists of financial materiality, and that is the impact on the enterprise value, on the firm value. But double materiality also consists of impact materiality, that is, the impacts that companies cause externally. Now, many corporate impacts are not yet fully reflected in a firm's share price or even in regulation. In other words, there can be trade-offs between internalizing negative externalities and firm value. So the evidence is sobering. The Carbon Majors 2024 database shows that 57 companies are linked to 80% of greenhouse gas emissions since 2016. And rather egregiously, many state-owned enterprises and investor-owned companies have continued to expand on fossil fuel operations, notwithstanding and subsequent to the 2016 Paris Agreement. So the implication is this: if boards should continue to focus exclusively on primarily on financial materiality, there can be a risk of causing more negative externalities. I think we should rethink how corporate law can be used to require boards to internalize externalities. Now, this is a really interesting paper by Roy Shapira and Ludiz and Gallis. With regard to the question that they raised, this is the title: Is pollution value maximizing the DuPont case? And the answer is yes. And they did a survey of major US companies. And do profit maximizing companies generate significant externalities? And they said yes, more than 30%. And you know, the three primary mechanisms that have been used to hold companies accountable: regulation, litigation, and reputation, all simultaneously failed in the DuPont case. This case is particularly egregious because DuPont manufactured Teflon, and in the process of manufacturing Teflon in its factories in West Virginia, it emitted toxic chemicals for many years, which entered the water supplies of West Virginian residents. And needless to say, many people fell sick as a result of these toxic chemicals. And there was also plant explosion, which resulted in deaths. And you know, the irony is that DuPont, prior to these scandals being discovered, had a reputation among its stakeholders and the community for good corporate citizenship, for contributing substantially to the welfare of the community. But, you know, there's a lot of public relations, right? What was discovered is that based on the board papers, as a result of investigative reporting, the directors of DuPont took the view that it would have been value maximizing to keep on polluting as long as the probability of detection and conviction was less than 19%. This is extremely cynical, but I would not be surprised that this could be one of the calculations that many of the carbon majors make when they decide to continue with the fossil fuel operations. And in this particular case, reputational constraint failed because there was a large time lag between pollution and the detection, which dilutes the force of reputational concerns, because by the time the scandals were discovered, most of the directors have retired or would have disappeared or would have, passed away. And as is typical of many of the carbon majors and large petroleum companies, DuPont fought aggressively to dilute and to limit the strength and the diffusion of bad news surrounding these scandals. They used their entire PR machinery to contain the scandals. But what was most tragic was that the class action lawsuits that were brought on behalf of the residents of those who passed away were dismissed in 2023 because the causation requirement under the US state laws failed to be satisfied. Now, I mentioned earlier, or I alluded to earlier, why am I discussing the external dimension of directors' duties? The first is the universal ownership debate. Some of you may be aware of it, some of you may not be aware. In essence, okay, I'm simplifying this, large asset owners care about portfolio-wide returns and not just firm-specific performance. So they want the high-emitting firms within their portfolios to internalize the negative externalities, because the failure to do so could result in a reduction in the overall portfolio gains. And the implication is that directors should promote the interests of universal investors in addition to the interests of firm-specific investors. This implies that directors should address negative externalities. And mind you, the universal ownership debate is not just restricted to the academia. It has, practical implications as well. Many of the world's largest asset owners identify themselves as universal owners, such as Singapore's Temasek Holdings, such as Norway's Norges Investment, and in Australia has, which is a superannuation fund, publicly identified on its website that it is a universal owner. And the second development, as I mentioned, is the EU CSDDD and the EU CSRD. Although both pieces of legislation do not impose duties on directors per se, they impose duties on companies to report on double materiality. And the CSDDD imposed duties on companies to identify, to mitigate, and to end the adverse impacts that the companies cause to the environment and to human rights. And so these two pieces of legislation would have the indirect effect of changing the environment of expectations and the market norms, which will actually elevate the standard of care that directors are subject to. State-owned enterprises, and this is a major aspect of the development. Okay. The interesting thing about state-owned enterprises is that they do not have profit maximization as their dominant goal. State-owned enterprises are complex creatures. They have multiple purposes. They are set up, yes, to make money, to generate profit, but they are also set up to produce affordable goods and services, to generate employment, and they are conduits of government's social, economic, and climate policies. The question is whether Anglo-American law allows directors to address these external considerations. So now let's take a look at the really interesting and important 2024 decision that was handed down by Vice Chancellor Travis Lester in the case of McRitchie versus Zuckerberg. So when I wrote this paper, it was my first time, writing on Delaware law, and I was and I wanted to make sure that I got it correct. So what I did was that I actually emailed the paper to the judge, Vice Chancellor Travis Lester from the Delaware court. And although I absolutely no prior context with him, I know, of course, I've read his judgment, I've read about him online, but no prior context. I wrote to him on LinkedIn. I said, I've written this paper about a judgment. Would you like to take a look? Within a couple of hours, he said yes. And within a few days, he came back with detailed comments. And I was very happy to know that I got the Delaware law correct, and he gave me substantive and concrete suggestions on how to further improve the paper. So he looked at the other references and other arguments pertaining to US law in other parts of the paper. So I'm extremely grateful to him. Now, why is this judgment interesting? This judgment concerns universal ownership debate. So the plaintiff alleged that Meta's directors and officers, including Mark Zuckerberg, breached their fiduciary duties by seeking to generate only firm-specific shareholder value. And the plaintiffs alleged that the directors and officers of Meta are failed to protect the interests of diversified and universal investors. So what did the court hold? It's a magisterial 100-page judgment, not the 500-page judgment that Elizabeth told me about. And VC Lester held that directors under Delaware law owe duties to the company and its firm's specific shareholders. Under Delaware law, there is no duty on the part of directors to diversify or universal investors. And as such, there is no requirement on the part of directors to internalize negative externalities solely to protect the financial interests of universal shareholders. Yes, I mean, this may not be the result that some people hope for, but B.C. Lester actually laid down two important qualifications. He said that number one, directors must consider broader economy harms. That is, directors must consider negative externalities when corporate decisions consistently or profoundly harm the broader economy, and in doing so, harm the financial interests of firm-specific shareholders. And the second qualification is that he said that directors can address broader economy harms if shareholders consent to such a conduct. Okay, so let's take a look at these two qualifications. Now, I think there is something quite problematic here, because the threshold is extremely high. First, the director's actions must consistently or profoundly harm the economy, or for that matter, the environment or climate or community. And second, the harm to the economy or to the broader constituency must harm the financial interests of firm-specific shareholders. Now, if you apply this test to most carbon majors, directors are unlikely to be in breach of their duties. And the reason is actually very simple. This is because even if the minority shareholder, a minority shareholder of Shell or Chevron, or BP, or any particular carbon major, can show that the directors have caused the company to consistently or profoundly harm the climate or environment or the economy, directors must still show that this harm has resulted in financial losses to the company, which has led to a diminution in the share price, which has adversely affected them. Okay. It is one thing, in my view, to show that carbon majors collectively, as a whole, cause profound harm to the climate, which will translate to macro harm, such as persistent GDP losses or systemic market impact. It is another thing to show that the directors of this specific carbon major has caused profound or consistent harm to the climate, which in turn has led to a severe reduction in the share price of the company for a very simple reason. Okay, this is because the financial performance of a firm depends on a multitude of factors. Now, B.C. Lester also addressed another point. When can directors address externalities? So he said that first, directors can address negative externalities if they are rationally related to firm-specific financial performance. This is nothing but the enlightened shareholder primacy model, and this is actually the internal dimension of directors' duties, which I mentioned at the outset. But secondly, and what is interesting is that he said shareholders can amend the corporate constitution. So the corporate constitution can be amended to require that the corporate purpose includes protecting the climate and nature. And because directors need to act in accordance with the corporate constitution, they will be required to take actions to mitigate climate change. He also said that the corporate constitution can require that directors exercise their powers to address negative externalities. Okay, and he also said that the corporate constitution can be amended to specifically address the beneficiaries of directors' duties. That directors have to discharge their duties in order to benefit the climate or nature. Now, as I will show shortly, drawing from a UK example, all of this is highly problematic because in a shareholder primacy jurisdiction, such as the UK and the US, it really depends on the wishes and the incentives of the shareholders. Okay. I've mentioned this earlier, okay, regarding CSDD and the CSRD, okay. But what is interesting here, as I've alluded to at the beginning, is that both pieces of legislation has extraterritorial effect. So this means that it applies to overseas company that meet the threshold requirements, okay? And so the question is, what implications does the CSDDD or the CSRD have for directors of non-US companies, non-EU companies, which will include US companies, which will include Australian companies, provided they meet the threshold requirements stated in these two pieces of legislation. Now, it has been argued recently that directors of US companies could breach the CAMA oversight duties if CSDDD related risks are central to the company and directors of these in-scope companies fail to put in place systems and process to detect and address this risk, or if directors persistently ignore red flags. Okay, state-owned enterprises. State-owned enterprises is interesting, but has been neglected. And I wonder why, because SOEs are major players. They account for significant emissions. At the same time, they are also leaders in decarbonization. Now, according to the Carbon Majors database, 13 out of 20 of the top carbon majors are SOEs or under state control. And 4 out of these 13 are from China. And SOEs are also leaders in renewables. More than 50% of the planned investments globally come from SOEs. And apart from this interesting feature, the SOEs are extremely important in the climate action debate. SOEs also have multiple purposes, which distinguish them from the investor-owned companies. Okay, now, I will now examine 3 arguments that can be used to support the external dimension of directors' duties. The first is to incorporate nature into corporate constitutions, and that is consistent with what the Delaware Court stated in McRitchie versus Zuckerberg. Okay, now, about 3 years ago, when I first came across this, I was quite shocked. It was quite sensational, at least at the time when it was published by Guardian. Faith in Nature is a beauty cosmetics company, and it's quite similar to Body Shop. So when Faith in Nature announced that it has actually appointed Nature to its board of directors, and the company must listen to the voice of nature, I was wondering, how is that possible? Has the UK legislation been amended to grant separate legal personality to nature, just as in some jurisdictions it has granted separate legal personality to rivers, But what Faith in Nature did was actually quite innovative. And it's not just Faith in Nature. There are other private companies in the UK that have taken seriously what Faith in Nature has done. So Faith in Nature have amended their corporate constitution to include nature clauses. Corporate object clauses now include references to nature. And directors' duty clauses now include references to nature, and a nature guardian must be appointed. In other words, a director must be specifically appointed to protect and to advance the interests of nature. And there's also a definition of nature in the corporate constitution. And if the nature guardian's advice, namely the director has been appointed to advance the interests of nature, if his or her advice is rejected, reasons must be given. And the nature guardian must be satisfied with the annual reporting issued by the companies. Now, why do these matter? Because this is private ordering at a very high level that could actually promote climate action. Okay. It operationalizes the external dimension of directors' duties. Impact materiality is being written by shareholders into the corporate constitutions of UK private limited companies. And all of these sounds quite promising and could be possibly a way forward for shareholder primacy jurisdictions, consistent with the 2 qualifications that have been laid down by VC Lester and McRitchie versus Zuckerberg. Unfortunately, there's a dark side to it. Now, there are 5 problems. The first problem is that there's an absence of prioritization rule. What if there is a conflict between protecting nature's interests and firm profitability or share price? Which one should prevail? Which one should be prioritized? It is not stated in the corporate constitution. The nature guardian, the sole director that's been appointed in the board to advance nature's interests, can be removed by an ordinary resolution if more than 50% of the directors or the shareholders think that, no, we don't need you anymore, nature guardian. You are just a nuisance, a pain in the ass. Let's sack him. Yes, this is permitted under UK law. And all these, let's say if a private equity investor and let's say midway through the life of the company, they need additional financing and approach a private equity investor or a hedge fund, and the investor said, all these fanciful, pro-nature clauses is such an obstacle to profit maximization. Let's get rid of them. Yes, these pro-nature clauses could be amended through special resolution. So as I said, the problem with private ordering, the problem with incorporating nature, pro-nature, pro-climate, pro-stakeholder provisions in the corporate constitution is that it can be removed, and directors, pro-nature, pro-stakeholder directors can be removed by shareholders. And because ultimately UK and US corporate law is a shareholder primacy jurisdiction by orientation. Okay, now take a look at this other example. The second argument in which we can use to support the external dimension of directors' duties is a shareholder preference argument. Okay, I'm sorry. So the second argument is this. This is the shareholder preference. So Hart and Zingale said that, look, for a long time, scholars and policymakers take the view that under Delaware law and under the laws of many US states, directors are required to promote and to protect the interests of company and shareholders, which is equated with shareholder value, share price. But shareholders' interests can be equated with shareholders' preferences. And therefore, if shareholders have non-financial preferences, such as social, ethical, ESG preferences, under Delaware law, it will be legally permissible for directors to promote these non-financial preferences and interests of shareholders. And there are mechanisms to give effect to pro-ESG shareholder preferences, which includes linking executive compensation to ESG metrics, shareholder proposals, private engagement by shareholders, and the company and shareholders can actually enter into agreements to give effect to ESG. And there's also evidence that ESG metrics and executive compensation are now quite common and can correlate with improved ESG outcomes. And there's also some evidence that shareholder proposals and private engagement by shareholders can shift corporate practices. Okay, but there's also significant counter evidence. Many institutional investors, and I'm drawing from the US empirical literature, are financially motivated, consistent with climate's financial materiality. A revealing study shows that the behavior of the principles of responsible investment signatories are extremely hypocritical. The largest asset managers often vote against ESG proposals. And surveys show a minimal willingness on the part of some of the largest ESG asset managers to sacrifice small amounts of financial returns, notwithstanding that the PR materials of these asset managers claim that they are pro-ESG and pro-climate action. And as many of us know, there is actually a huge backlash in several red states in the US, anti-ESG backlash. Many asset managers in the US, including BlackRock, have been sued for breaching their fiduciary duties precisely because they took into account ESG factors in their decision-making process. So the bottom line is that catering to shareholders' preferences is definitely not a good basis for the external dimension of directors' duties because of the risk of sacrificing firm-specific shareholder returns, which are likely to be opposed by the largest asset managers and many institutional investors. Now, my argument here is that, and here comes to the contribution I wish to make to the literature, is that in my view, I think the SOE path is slightly more promising. And I think that there can be an alignment of the duties of directors, the duties of the asset owner, the state as the asset owner, and the state as the controlling shareholder. Now, as we all know, directors are required to act in good faith in the best interest of the company. But what does it mean for a directors of an SOE to act in the best interest of that SOE? Recall that SOE has multiple purposes. It is established not only to pursue profits, but to generate employment, provide affordable goods and services, and they are conduits of government, social, economic, and environmental policies. And therefore, directors are permitted, and I should add, directors are legally required to take into account these external considerations, even if it's not related to SOE-specific shareholder returns. Now, in an SOE, the state is the controlling shareholder. The state, as the controller, has public interest mandates. The state has to act in the public interest. And when the state becomes a controlling shareholder, the fact that a state has to act in the public interest does not go away. And given that as a controlling shareholder, it can easily appoint and remove directors and exercise oversight of the directors, and of the SOE, this will actually increase the alignment between directors' duties and the controlling shareholders' wishes. Now, the state is also an asset owner. It is also a universal investor. So as an asset owner, it manages diversified portfolios, which will include both SOEs and non-SOEs. And therefore, as an asset owner, it seeks to optimize long-term risk-adjusted returns for its beneficiaries, many of whom are public pensioners. And therefore, it can rationally decide to internalize the negative externalities of one or several of its high-emitting companies within its portfolio if it could result in an overall portfolio gain. But as I said, the calculus can also go to the other way around, as I'll show shortly. And there's also a time horizon match, right? Because the state as a controlling shareholder of SOE and the state as the asset owner adopts a long-term approach. This means that they can focus on intergenerational equity, health impacts, and systemic climate risks that go beyond short-term or mid-term shareholder returns. Okay. Now, I've come to the last part of this presentation. Okay, China. Why China is interesting? China is the world's largest emitter, and SOEs in China dominate coal generation, but SOEs in China are also world leaders in decarbonization. Now, if you look at this slide from The Guardian, it says that China has accounted for the majority of the fossil fuel emissions for almost 20 years. Okay, so the first prize goes to China, the second prize, goes to the US. But if China is one of the world's, or arguably the world's worst greenhouse gas emitter, China is also a world leader in decarbonization. Many of us here who read The Guardian, The Economist, or Financial Times will know that how critical The Guardian, Financial Times, and Economist has been of China. And I think rightfully so, especially with respect to its human rights record. But I was pleasantly surprised to see this, in Guardian. There's only one player. Why China is becoming a world leader in green energy. That's from The Guardian, which has been traditionally critical of China. And what about economists? China's clean energy revolution will reshape markets and politics. The world's biggest manufacturer now has an interest in the world decarbonizing. The solution to decarbonization, the solution to a net zero world lies in understanding how China operates, specifically its state-owned enterprises. And therefore, we need to understand the modus operandi of directors and managers and how they manage and run state-owned enterprises in China. This is, I know that time is running short, but this is just a brief overview, okay, of the complexities of SOEs in China. Right in the middle, you have the state-owned enterprise, the SOE coal-fired power plant. And you have the state-owned bank, which is another SOE that provides financing to the SOE power plant. You have the coal supplier, with which the SOE power plant does business with, which is also an SOE. You have the grid purchaser, which is also the SOE. And above that, you have the state, which is the controlling shareholder and the asset owner, not only of the SOE power plant, but also of the other SOEs. And therefore, for Chinese SOE is enmeshed within a system of multiple SOEs, and therefore it is overly simplistic for directors and controlling shareholders of a coal-fired power plant SOE to pursue only firm-specific, SOE-specific shareholder returns. In other words, the Anglo-American model in which we are only concerned about firm-specific shareholder returns, it's not applicable in China, and it's also not applicable, as I will show shortly, in government-owned utility companies elsewhere in the world. And therefore, directors of SOEs do take into account external considerations, okay, and not just firm-specific, narrow firm-specific returns. Now, I want to return to this puzzle, okay? So, why is it so strange that, China is considered by Financial Times economists as a world leader in decarbonization? At the same time, it still continues to build coal-fired power plants. What is happening? Is the world's worst emitter and the leader? How is that possible? How do we square this paradox? And where do directors' duties fit in, okay? So in other words, why is China continuing to build coal-fired power plants if the risks of stranded assets are real, if they have made net zero, if President Xi Jinping have actually declared the pledge that China will become net zero by 2060? And the answer to this puzzle, in my view, is that Chinese SOEs decisions are guided by broader economic country analysis, not narrow firm level profitability, okay? So according to the Chinese government, coal projects can break even economically within 7 years, okay, under their assumptions, whereas firm-specific cash flows might not turn positive for 21 years. So from a country-level lens, coal can appear beneficial to the economy, to the country in the short term. But from a firm-specific lens, it also looks unattractive. So in other words, China is also using the revenue and the profit that is generated from these coal-fired power plants to finance its decarbonization projects in relation to renewables. It is a world leader in electric vehicles as well as solar panels. Now, that's it. That is the Chinese government calculation. But scholars have argued that the Chinese government's calculation is erroneous because shadow carbon pricing shows that the net economic benefits that can turn negative. So even on the broader economic view, continued coal investments by the Chinese government can erode national welfare, erode economic welfare. Now I've come to the last point. What is the governance implication of the Chinese SOEs, for this paper? And the point that I want to raise is that for SOE directors acting under multi-purpose mandates, and for the state controlling shareholder and asset owner, in my view, facing down coal operations is consistent with their fiduciary duty if future externality costs are properly accounted for. But in my view, the Chinese government has not properly accounted for the future externality costs, which explains why they are still ramping up on coal-fired power plant operations. One final point, and you may be wondering, okay, so is this just something about China? What's that got to do with the rest of the world? Yes, China is a world leader in decarbonization and is the world's worst greenhouse gas emitter together with the US. I think that this paper has lessons for other countries. It has implications for government-owned utilities in the US and in other countries, and possibly, and I said possibly Australia. In the US, there are about 2,000 such government-owned utility companies, accounting for more than 15% of the production capacity in the US. And these state government-owned utility companies have multi-purpose mandates. And therefore, the external dimension of directors' duties is an intrinsic core of these state government-owned utility companies. And the second point I want to raise is this: the universal ownership debate is not all rosy, okay? Recall that according to the universal ownership proponents, asset owners, universal owners have an incentive to cause the companies within its portfolio to reduce its negative externalities, because the failure to do so will lead to a reduction in the overall portfolio returns. The Chinese coal-fired power plant example shows that the reverse can happen. Now, I want to end with this point. SOEs will become much more important in the years to come, particularly in light of the recent the International Court of Justice advisory opinion on climate change, in which the ICJ requires states to regulate the activities of private actors as a means of due diligence. I said private inverted commas. And the most important private, basically non-state entities will be the state-owned enterprises. So thanks very much. Thanks.
Thank you so much for such a thoughtful, original presentation, and also one which really for this topic ended on a fairly positive note. Please join me in thanking Professor Lin for a really stimulating presentation.